Okay. Hello, everyone, and welcome to the Charity and Security Network's webinar, Due Process, the State of U.S. Treasury's Terrorist Listing Procedures. This is July 29th, 2019. I'm Kay Ganan, the Director of the Charity and Security Network, and welcome you all, and also thank our two expert speakers today, Alan Kabat from Bernabei and Kabat, and Hina Shamsi, the National Security Director at the American Civil Liberties Union. Today's webinar will cover a lot of material, so I'd like to review with you the process for you to answer questions. After each speaker, there'll be a few minutes for some immediate questions, and then after both of them have presented, I'll ask a few questions, and then we'll open it up to your questions. You will see at the bottom bar, should be on your screen, a Q&A folder. You can use that to ask your questions. Our webinar tool does not allow us to have you ask them by voice, so just type them in there and we'll track them as we go along. Also, you'll see a chat box where you can put in comments addressed either to everyone or just to the panelists. There's a drop-down box when you hit that chat that allows you, you see the two boxes at the bottom, either to all panelists or all panelists and participants. So, and this webinar is being recorded. This and the PowerPoints will be posted on our website at www.charityandSecurity.org. So first, I'm going to provide a very brief historical background on the application of Treasury's terrorist listing procedures to US-based charities. So we get the next slide. Get the next slide. Okay. Thank you. This all began with passage of the Patriot Act in 2001, at least the major problems. The Patriot Act was a series of amendments to otherwise existing laws, primarily, that dramatically expanded powers of the government to take action, and also the scope of what was prohibited or considered to be support for terrorism. That included the prohibition on material support of terrorism, sanctions laws under the Emergency Economic Powers Act, which led to issuance of Executive Order 13224 in days shortly following the 9/11 attacks that invoked broad powers for Treasury to act in dealing with what it decided were supporters of Al-Qaeda. There were also amendments to the Bank Secrecy Act that have had an impact on the nonprofit sector. Can we get the next slide? These post-9/11 executive orders canceled exemption for humanitarian assistance that is in the sanctions law. Basically, the IEPA, the International Emergency Economic Powers Act, exempts donations of articles such as food, clothing, and medicine intended to be used to relieve human suffering. But that president can cancel that exemption if he or she finds that such donations would impair ability to deal with the emergency or would endanger U.S. armed forces. And beginning with Executive Order 13224, this exemption has been routinely canceled in terrorism-related executive orders. They don't explicitly say that. It's wrapped up in legalese that refers to the section that allows cancellation of the exemption, but basically in the years since 9/11, that exemption has effectively been canceled for most terrorism designations under the sanctions laws. We get the next slide. These new powers under the Patriot Act were used to shut down 9 U.S. charities between December 2001 and January 2009. There has not been a shutdown of the U.S. charity using these powers since that time. There are two categories. Charities shut down pending investigation into whether or not they should be designated or listed as a supporter of terrorism. And most of those were later designated. And then those that were just out and out designated. And this list is available on our website, and it will be available in the PowerPoint that's posted there as well. Next slide. The consequences of designation for U.S. charities are very severe. The charities' funds are frozen, funds that are subject to U.S. jurisdiction. Records, property, equipment can be seized, and any other U.S. person or entity, including banks and foundations, donors, other nonprofits, are barred from engaging in transactions with the listed group. There's limited access to funds for pay for legal representation and automatic revocation of tax-exempt status under Section 501(c)(p). Appeal rights are limited, and of course, there's great reputational damage that goes along with such a designation. Most of the cases of U.S. charities are shut down are chronicled in some detail in a 2008 report from OMB Watch and Grantmakers Without Borders called Collateral Damage, and the link is here if you'd like to get more details. Get the next slide. And now we will move forward to hear more of the legal background around designation and the whole legal framework for this regime from Hina Shamsi, the National Director for National Security at the ACLU in New York. Hina?
Great, thank you so much, Kay, and thanks everyone for joining this afternoon. I am having a few technical difficulties here, so you're not going to see me on camera, but more importantly, you will have the PowerPoint. So, Raquel, next slide, please. What I'm going to talk about today are the two key designation regimes and their legal frameworks. As Kay pointed out just a short minute ago, the consequences of designation under both regimes, the Foreign Terrorist Organization regime as well as the specially designated global terrorist designation regime, are draconian. And what I wanted to do was to cover the legal authorities as well as the process of designation, or in certain cases blocks, which you'll hear more about, the consequences in a tiny bit more detail, as well as the administrative and judicial review that is available before Alan talks about some of the cases that are more specifically implementing or challenging these authorities. Raquel, if you'd take the next slide, please. So the first regime is the FTO regime, and that the authority for it comes under the Anti-Terrorism and Effective Death Penalty Act, which gives a significant amount of discretion, very broad discretion, to the Secretary of State to designate FTOs. The criteria for designation are here on your screen. The organization has to be a foreign one. It engages in terrorist activity, terrorism, material support, or retains the capability and intent to engage in terrorist activity or terrorism. Both terrorist activity and terrorism are legal terms. The first is defined in 8 U.S.C. section 1182A3B. Terrorism is defined in 22 U.S.C. 2656 FD2. And I can provide more citations after our webinar. But it's important to note how broad these terms are and how broadly they've been construed. The third criteria is that the activity or terrorism by the organization threaten the security of U.S. nationals or the national security of the United States. Again, broad terms. The FTO designation procedure, Raquel, if you could take it to the next slide, please, is set out in a bit more detail than the second regime, the SDGT regime. And it starts, in essence, with the Secretary of State assembling an administrative record. That record is done in consultation with the Secretary of Treasury and the Attorney General. And this process that I'm talking about is set out in regulation in 8 U.S.C. 1189. And it does require the Secretary of State to notify certain congressional leaders of the executive branch's intent to designate. The Treasury Secretary may then block the assets upon making a determination based on that administrative record, including blocking the assets of any organization, blocking any assets of the designated entity that are held by a U.S. financial institution. And we'll talk a little bit more about consequences, but it's important to note that the Secretary of State has to publish the designation in the Federal Register, and designation becomes effective upon that publication taking place. The consequences, as we mentioned, are draconian, and Raquel, if you could take it to the next slide for that, please. The consequences include, as I've mentioned, that the assets of the organization that are held by any U.S. financial institutions must be frozen completely. There are possible criminal charges for knowingly providing material support for that entity. And among those sort of follow-on consequences is that the Treasury Department, they may also then freeze those other entities' U.S. assets if it investigates them under the SDGT regime. And I just wanted to flag that before coming to the SDGT regime in a bit. And the FTO designation, it's important to emphasize, may also have immigration consequences, in that non-citizen members or representatives of a designated FTO are barred from entry into the United States, and those present in the United States may face removal. So important, especially in these times, point to note. Given the really significant consequences, what are the avenues of redress that are available to an FTO? Well, there are two. One is the administrative process, and two is the judicial review process. It's important in this context that these procedures are applying after designation takes place, after the draconian consequences are put in place. Next slide, please. So for the administrative review process, an FTO, remember, a foreign terrorist organization, may only seek administrative review, that's internal agency review, 2 years after it has been designated, and that review process is limited. The designated FTO submits to the Secretary of State a petition for revocation with evidence showing that the organization's circumstances are sufficiently different. I will note here that given that notice has often been sorely lacking, trying to figure out how to present that information can itself be challenging. After the revocation petition, within 180 days, the Secretary of State needs to make a determination about whether revocation is warranted, and that determination would be published in the Federal Register. In making their determination, both for initial designation as well as for the administrative review, the Secretary of State can rely on, and I think throughout we've seen it rely on, classified information that the designated entity and generally its legal counsel cannot see. Now, FTO designations can separately be revoked if the Secretary of State determines that there are grounds for doing so and notifies Congress. Congress can also pass legislation to revoke designation, but that is and can be fairly unlikely. So even though the authority is there, the challenge can be very uphill. With respect to judicial review, next slide, please. Judicial review for FTO designation is circumscribed in time frame, venue, and scope. It's available more quickly than administrative review, that's important to note, but the judicial review must take place within 30 days of designation, and the designated entity can only seek that review in the DC Circuit. Now, the DC Circuit has held in series of cases challenging FTO designation that it's going to limit its review to the first two criteria for designation. In other words, whether the organization is foreign and whether it engages in terrorism or material support for terrorism or has the capability and intent to do so. The DC Circuit has said that the third criteria, which is whether the FTO, the designated FTO's activities threaten US nationals or national security, is an unreviewable political question, meaning that the court will not look into it beyond the government's assertion. Now, with respect to what can be reviewed, it's generally limited to the administrative files that the State Department compiled, although again, the government may present classified evidence to the court ex parte and in camera. Next slide, please. And the DC Circuit may only overturn a designation if it concludes that it was arbitrary and capricious. So essentially an Administrative Procedures Act standard. Constitutionality may be at stake, but likely only if the court is adjudicating constitutional questions if the designated FTO has property in the United States, or if it has and can show a presence and substantial connections here. The DC Circuit may also overturn a designation if it determines that the administrative record, as supplemented by classified information, lacks substantial support. This is still a fairly deferential standard. Or the fourth prong here, if the DC Circuit finds that the designation procedure does not comply with the procedural requirements under EDPA, which I summarized before. Again, here, very deferential, limited in scope and venue, and as Alan will talk about, has been an uphill task, although there are important rulings with respect to what can be provided and what can be reviewed in legal cases that have come before. The next key regime, the SDGT regime, is promulgated under IEPA, as Kay pointed out, the International Emergency Economic Powers Act, which gives the president very broad authority to declare a national emergency with respect to a specified threat and to take action in response to it. The Executive Order 13224 that President Bush issued in 2001 claims the authority to impose broad sanctions on people or organizations designated as STGT. And key distinction, an obvious one but important to point out, is that the Executive Order 13224, apologies for that typo there, can apply to US as well as foreign organizations and individuals. Next slide, please. Before I get to the specific criteria for designation as an STGT, bottom line is that they are very vague and have, based under fact patterns we've seen, resulted on guilt by association. EO 13224 does not include a set evidentiary standard that the government must meet. And critically, the Patriot Act of 2001 also amended IEPA to permit the Secretary of the Treasury to block the assets of an entity pending investigation, meaning that it doesn't have to be designated in order to have the same kinds of consequences imposed while investigation is ongoing. And the criteria for both designation and the block are the same. Next slide, please. The first couple of criteria apply to foreign entities and individuals, which I'll refer to as persons here. The first was, the people and entities on the SDGT list at the time that President Bush issued the order, and those added right after that and since then. The second criteria relates to foreign persons, and they have to be determined by the Secretary of State to have committed or to pose a significant risk of committing acts of terrorism that threaten the security of U.S. nationals or national security, foreign policy, or economy. Again, very broad. Next slide, please. The third and fourth criteria apply to both foreign or U.S. persons, and here it's a determination by the Secretary of the Treasury that these are persons, again including entities, that are owned or controlled by or acting for on behalf of people included in the SDGT list, as well as, and this is the fourth criteria, foreign or U.S. persons that the Secretary of the Treasury determines meet these very broad standards of sponsoring, providing financial, material, or technical support or other services to acts of terrorism or the persons listed on the SDGT list or otherwise associated with the SDGT list. So moving on to the designation procedure. Again, a couple of threshold points is that unlike the FTO scheme, the process for designation is somewhat unclear. It's not laid out in any statute or regulation, and the Treasury Department's descriptions of the process on its website, in litigation filings, and in congressional testimony have varied over time and do not always comport with the experience of people who are designated or organizations that are designated. The Treasury Department describes the designation procedure as follows. Next slide, please. It involves an investigation into the party to be designated, the creation of an administrative record, which can include classified information, and consultations by the Secretary of the Treasury Department with the Secretary of State and the Attorney General. If the Treasury Department deems that the administrative record that it has compiled is legally sufficient, which means that the record shows a reasonable basis and a low standard to determine that the designee meets the criteria, again, which are broad, then the entity can be designated as an SDGT. Its assets can be frozen without prior notice, and the designation will be published in the Federal Register. Next slide, please. It's important to note that the blocks pending investigation, i.e. short of formal designation, have been imposed without prior notice, and the effect of and consequences are the same as SDGT designation. So the next slide has consequences of both SDGT designation and the block pending investigation, which are similar to FTO designation. All property and interest in property in the US or that later come within the US or within the possession or control of US persons are blocked. And this also means that any transaction or dealing with an SDGT by a US person or within the United States, including contribution of funds, goods, or services to or for the benefit of the designated entity are prohibited, and criminal and civil penalties may apply for the violations. Now, under OFAC regulations, a designated entity or an entity that is blocked pending investigation is subject to certain licensing constraints in paying for legal services. Very generally speaking, OFAC has issued a sort of general license that provides services may be provided without falling afoul of the sanctions regime. Legal services may be provided without falling afoul of the sanctions designation regime, especially with regard to legal services, administrative or judicial, within the United States. It's important for blocked entities and their lawyers to be familiar with these regulations and ensure sort of compliance with them. A license is not required for pro bono representation. The licensing and legal services requirements are at 31 CFR, section 509-506. So moving on then to administrative review. The next slide, please. The process for administrative review is set forth in very general terms, again in 31 CFR, section 501807. And the entity may submit arguments or evidence to attempt to establish that there isn't a sufficient basis for the designation or block. And it can also propose remedial steps, examples of which are provided. It may request a meeting with the Treasury Department, but as we've seen, the Treasury Department reserves the right to refuse a meeting, and the Treasury Department will issue a written decision in response to the entity's submission. There are no time limits for an entity to seek this relief in the regs, and importantly, there's no time limit for the Treasury Department to respond to a request for agency or administrative relief, and in past cases, it can go on for a significant period of time. For judicial review, the next slide, please. Judicial review for U.S. person entities is not subject to the same kinds of constraints, generally speaking, as the FTO regime. And the U.S. person entities have a full range of constitutional protections and should assert them. Alan is going to talk about two of the key cases, one of which we were co-counsel on, and it would be important to know that, in fact, the courts have pushed back with respect to seizure in violation of the Fourth Amendment and imposition of and recognition of due process requirements. The final slide, please. So basic points, one that just to point out, but worth knowing, especially for those concerned about impact on U.S. persons and U.S. civil society. The SDGT regime applies generally to U.S. persons. There is a caveat when the government asserts that a U.S. person may also be potentially an FTO that I think Alan may talk about. The U.S. government has not designated or blocked a U.S. Muslim civil society organization under the SDGT regime since Kindheart. So it would be a fairly significant departure for it to do so. But having said that, the authorities are broad. And another important note is that AIPA is very broad. President Bush established EO 13224, interpreting his authority under that. And a real significant concern is that another president could create another designation regime under AIPA that would be applicable to US individuals or entities. But of course, it would be important to emphasize that constitutional protections would still apply. Thanks, Kay. Back to you.
Thank you. Thank you very much, Hina. I'd like to move on now to the litigation that has taken place relevant to U.S. charities and this entire legal regime. You've heard the legal framework from Hina, and she is an expert at the intersection of national security and counterterrorism law and human rights. And as she mentioned, both she and Alan Kabat have litigated several of these cases in the courts, and in the Kineharts and El Haramain cases with some degree of success. Alan Kabat is a partner at Bernabei and Kabat in Washington, D.C. As I said, has participated in many of these cases, and I will now turn the mic over to him to present the litigation history. Thank you, Alan.
Thank you, Kay, for the introduction and for setting this up, and thanks to Hina for the very helpful legal framework. Can we go to the next slide, please? As Hina mentioned, there are two sorts of the terror designations. Just to give you an idea of the volume of them, the Department of State has only designated currently 68 foreign terror organizations, but that includes a lot of aliases or groups that have multiple names according to the Department of State. In contrast, the Department of Treasury, Office of Foreign Assets Control, had a list of 1,313 pages. Now, even though that list includes a lot of duplicates, there are still far more people and entities designated by OFAC as opposed to the Department of State. But since they're both potentially relevant to U.S. organizations, I'll discuss both of them. Now, U.S. groups can actually fall under the foreign terror organization process of the Department of State if the Department of State claims that a U.S. group is an alias of a foreign group. And if you could turn to the next slide, please. And that's what happened in these two cases that the D.C. Circuit handled, the People's Mujahideen Organization of Iran and the 32-county committee. In both of those cases, the Department of State, when they designated a foreign group, one in Iran and one in Ireland, they also designated a U.S.-based group that they said were aliases of the foreign groups. And as Hina mentioned, in order to have a constitutional due process or First Amendment challenge to a Department of State designation, you need to have property or some other physical presence in this country. Well, the People's Mujahideen Organization had an office in the National Press Club building, and the D.C. Circuit held that was sufficient physical presence. 32 counties did not have an office. They had several volunteers in Brooklyn, New York, and those volunteers had home offices. Well, they also had a post office box. D.C. Circuit said that wasn't enough. So 32 county was out of the game by then. But the People's Mujahideen had some very interesting litigation that I'll talk about. And if there's no due process required because it's either a foreign organization or they don't have sufficient property in this country, then you only do what's essentially like an Administrative Procedure Act challenge. Does the administrative record have, quote, substantial support? And nobody had ever won that kind of a challenge. Let's go to the next slide. In the People's Mujahideen Organization case, the D.C. Circuit initially came out in 2010 with a quite strong decision finding the due process was violated because due process, as you probably know from the Supreme Court cases, required both notice and an opportunity to be heard. But here the state gave either no notice in advance, well, that was okay, but no opportunity to be heard, no opportunity to rebut the unclassified portion of the administrative record. And state did not explain how they determined which sources were credible and how the evidence supported the designation. So that was a strong due process violation. That's the 2010 decision of the D.C. Circuit. Can we go to the next slide? And then in 2012, at that time, the State Department designation process, the designations only lasted for 2 years, and you had to be redesignated every 2 years. So what the People's Mujahideen Organization did was they challenged the redesignation on the grounds that the Department of State still had not issued any decision on their request for reconsideration in the 2 years. And in the second decision in 2012, the D.C. Circuit ordered state to act on the petition within 4 months, and otherwise the petition for mandamus would be granted. And everybody was sort of wondering, well, what's going to happen? Well, what did the state do? Did they explain how the evidence supported the designation? No, they did not. Instead, state simply delisted PMOI. People moved to Hayden without any ceremony a few months later. And so that was a very good result for that organization. And it does show pretty much the only way you can prevail under the Department of State designation process, which is one, you have to show you have a physical presence in this country, and two, you have to show your due process rights were violated. The next slide, please. Now, Hina mentioned the material support issue, and the material support statute, which is in Title 18, the Criminal Code, has been very controversial because many people view it as somewhat vague and unclear as to what kind of support or conduct is prohibited. And that led to the Supreme Court decision in Holder versus Humanitarian Law Project. The 6-3 decision was ruled in favor of the government and reversed the Ninth Circuit. The plaintiffs in the Humanitarian Law Project case were several individuals and charities, mostly in California, that wanted to work with organizations in Kurdistan, the breakaway republic in Iraq, and in Sri Lanka. And those organizations that they wanted to work with were viewed as terrorist organizations, but they wanted to be able to help the organization with peaceful advocacy and with training on enforcing their legal rights and other issues that they thought would not be providing actual support for terrorism, but instead a way to get these organizations to become perhaps more legitimate and moving away from terrorism. So they brought due process and freedom of speech and freedom of association claims. The district court in the Ninth Circuit agreed with the plaintiffs in part, so the government naturally sought review by the Supreme Court. And then one interesting aspect of this case is that it was very well argued by both sides. And Holder, the Attorney General at that time, he was represented by Alina Kagan, who was then the Solicitor General. It was actually her very first oral argument that she'd ever done, but she did very well. The Humanitarian Law Project was represented by David Cole of the ACLU. David, of course, needs no introduction. He did an excellent job, but he could only be able to convince 3 of the liberal members of the Supreme Court to rule in his favor. With a quite lengthy dissent in the decision, but of course it's a dissent. Can we go to the next slide, please? The key takeaway messages from the Holder decision is that the material support statute is not void for vague, there's no due process challenge, and essentially required knowledge of what that foreign terrorist group is doing. And in fact, it is forbidden to train members of a foreign terrorist organization how to use humanitarian and international law to resolve disputes, or to even teach the members of that group on how to petition the United Nations. He cannot work directly with a foreign terrorist organization. He can only engage in independent advocacy. The next slide, please. The Supreme Court made clear that it's only coordinated activity and not independent activity. Even if that independent advocacy might be viewed as promoting the group's legitimacy, that's still okay. That's a very narrow window that Holder leaves open. And the next slide. The next slide, please. As Kay mentioned at the outset, the executive order issued a few weeks after the 9/11 attacks allowed OFAC to designate individuals. I also want to mention that there are parallel designations by both the United Nations and the European Union. The European Union designation has the effect of blocking your assets in the European Union countries. the United Nations designation, in theory, will result in blocking your assets in any country that the United Nations member, although the implementation of that is somewhat unclear to me. But what we have seen in some other cases is that individuals who are successful in challenging their designations under the European Union and the United Nations were then able to use that to convince OFAC, the Department of Treasury, to be undesignated by OFAC. So one strategy in terms of the designation process is to start with either the United Nations or the European Union, convince them of why you should not be designated, then use that to convince OFAC. The next slide, please. And both Hina and Kay mentioned, once an organization is designated, the key thing, essentially the first thing you have to do is to get a license in order to represent them and in order to be paid, whether from block fund or unblocked fund, because you really can't do anything. The organization can't do anything unless they have attorneys who are licensed to represent them. And there's essentially two things you want to challenge. You want to challenge the seizure of whatever asset. Usually what they will do, OFAC will do it, they'll have the U.S. Marshal go in and seize all the computers, the office supplies, the publications, as well as the bank accounts. You also need to challenge the designation itself, whether under First Amendment grounds, due process grounds, or administrative grounds. Another thing to watch for, and what we've seen in several of our cases, is there will be a parallel criminal proceeding. And that's a whole nother webinar, but if there is a criminal proceeding, you have potential problem with Fifth Amendment self-incrimination issues, because the people who are witnesses, the director of the charity or the officers and employees may not want to testify in a designation proceeding because that testimony could be used against them in a criminal proceeding. So it just creates a very difficult and messy situation. Obviously, if that happens, you want to bring in a criminal lawyer who can help advise you navigate that process. Next slide, please. The first case I want to talk about is the Kind Heart case in Ohio. And Kind Heart was a charity that was set up, I think about 30 years ago, to provide medical support, humanitarian relief in Palestine, in the West Bank, and to the refugees elsewhere in the Middle East. And it was mostly geared toward supporting the people who are injured and the people who are refugees. The government, however, viewed them as supporting Hamas and the Palestinians, several other Palestinian organizations that were themselves designated. Now, in terms of the initial challenge was, in order to defend ourselves, in order to even challenge the designation, Kind Heart and its attorney needed to have access to all the documents that were seized, the computer files. And the judge allowed us to get that access. And initially, the government wanted all the documents to be reviewed only if the U.S. attorney's office, and the U.S. attorney would get to know which documents we were reviewing. But of course, that blocked our Sixth Amendment right to counsel, so the judge shot that down. So the first Kind Heart decision in 2009, a very good decision in terms of getting access to the blocked documents and information. The next slide. Then we get the second decision also in 2009, and this has to do with the due process issue. And just as with the State Department designation process, Judge Carr here found that OFAC blocking without giving Kind Heart an opportunity to respond to the Fourth Amendment seizure. We need to have noted prior to blocking the asset. And Judge Carr also found that the attorney's fee policy was applied arbitrarily. OFAC has since amended the attorney's fee policy. The next slide. Then we get the third decision in the Kind Heart case, but one more coming actually. Judge Carr issued a TRO, temporary restraining order, enjoining the designation as an SDGT. He found that since there was already a constitutional violation in the blocking, we had a strong likelihood of success on the merits, and also the reputational harm if the designation was allowed to go forward. Now, of course, the reputational harm already happened because there was publicity about search and seizure, but we were able to minimize that by blocking or preventing the designation. The next slide. And then we get into the fourth decision in the Kinehart case, which came out in 2010, a decision on the remedies. And consistent with the other case, Judge Carr required OFAC to give a notice of the basis, which she said would be an unclassified summary, the classified record. And instead of doing that, however, OFAC ultimately agreed to unblock the asset and to allow Kinehart to distribute the asset to other charities that were doing similar work in the Middle East. So we never did get the fully unclassified summary, the classified record. And what you're probably realizing is that when the court called the bluff on the government and say, okay, you need to give them an explanation of why they were designated in a sufficiently unclassified format, in both the PMOI case and the Kinehart case, the government folded and they just unlisted the organization. The next slide, please. Now, let's turn to the Al Haramain case. Al Haramain was a charity in Oregon, and that was affiliated, loosely affiliated with the charity in Saudi Arabia of the similar name. And the Oregon group initially, most of its effort were toward distributing religious material to prisoners in the United States and in Canada, and typically Qurans and prayer books and things like that. But then Al Haramain decided that it wanted to support refugees, Muslim refugees overseas. They started out by giving some support to refugees in Bosnia and the former Yugoslavia. Then they went on to give support to refugees in Chechnya, which is the southern part of the former Soviet Union. And it was the attempt to support the refugees in Chechnya that led to all the litigation. And essentially what happened in February 2004, the assets were blocked, all the property was seized. And then over the next half year, Bernabei and I spent a lot of time providing information to OFAC, and we kept making repeated demands for the document to form the basis for the designation, to no avail. Because in September 2004, OFAC designated Al Haramain, Oregon. So have the next slide, please. Even after the designation, we still continued to submit additional documents. We requested reconsideration. We sought explanation again, to no avail. So we filed a federal lawsuit, and was very helpful. We had David Cole, who was then a professor at Georgetown Law School, served as our co-counsel on this case. We made both due process and Fourth Amendment violation claims. The due process court wanted to classify the evidence, didn't only give us the reason for the investigation. Fourth Amendment violation, no search warrant. Next slide, please. And we were joined by a charity in Oregon that wanted to work with Al Haramain, so they had both First and Fifth Amendment claims. And the district court largely ruled against us on pretty much everything. The Ninth Circuit reversed on several key points. Could I have the next slide? And the Ninth Circuit held that while OFAC could use classified evidence, it violated our client's Fifth Amendment due process rights. Once again, we did not have adequate notice or opportunity to respond, i.e. a fully unclassified summary. What OFAC did was they gave us a 20-page summary, of which about 90% was redacted, blacked out. So we could not figure out from the remaining 10% why the organization was designated. They also found the Fourth Amendment violation, as well as the local group in Oregon, the Multicultural Association, had a First Amendment right to engage in coordinated advocacy, like a joint press conference. The next slide. And then after the designation, after the Ninth Circuit decision, we sought reconsideration. We demanded access to the unclassified record, and we said either give the attorneys a security clearance so that we can access the classified record, or give us a better summary of the unclassified summary. And just as in Kinehart, just as in the PMOI case, OFAC instead agreed to delist Al-Haramain and to distribute its assets. So although Al-Haramain no longer exists, the asset were able to be used for other purposes. Can I have the next slide, please? And one thing I mentioned at the outset is sometimes there would be parallel criminal or grand jury investigations of these organizations that create problems in trying to defend it. Well, here what happened is there was a criminal prosecution of Al-Haramain and two of the directors, and it was for alleged tax fraud and currency reporting issues. Since the organization was essentially defunct, the government abandoned the prosecution of the organization. One of the two directors was overseas and remained overseas, so he could not be tried. So that left the Oregon-based director to have a criminal trial against him. Now, initially, there was a jury verdict for the government. However, the Ninth Circuit reversed in a very strongly worded decision because there were serious Brady violations. What the Brady violation meant is that there were several key witnesses whom the government paid quite large sums of money to testify, but without telling the defendant. And there was also a failure to give an adequate summary to classified information. In response, did the government retry Mr. Citigati? No, they simply dismissed the prosecution, and they settled both the criminal case and the OFAC designated case in 2014. So, and one last thing I want to say, and then we'll talk about, and maybe the subject of future webinar. Some of you may be wondering about compliance issues. In other words, how do I avoid getting my group into the same problem that Kinehart and Al-Haramain have? All I can say really is you really need to know where your money is going. If you are sending funds or service or goods overseas, you really need to do a lot of vetting and have very tight control over where the money is going. And I think both Al-Haramain and Kinehart might have been able to avoid this if they had spent a little more time and effort on compliance upfront before engaging in their overseas activity. Thank you. I'll turn it over to Kay. Thank you very much.
Thank you. Now we have some questions that have come in from participants, and I have a few of my own. One thing I wanted to ask, I've always been curious about, with the relationship between the State Department designation of foreign terrorist organizations and the Treasury Department Executive Order 13224, do foreign terrorist organizations have more rights than U.S. charities? Hina and Alan, I'll ask you if you could address that one.
Sure. Essentially, the process is almost like a black box to us. It's not clear to us why some entities are designated by state while most of them are designated by OFAC. I mean, the way the guidelines and the regulations are written, an entity could be designated under either or both. And for whatever reason the government has done, probably 95% of the designations by OFAC. But why, I can't tell you.
Hina, do you have a comment on that one?
Just with respect to greater rights, I mean, obviously, U.S. people and entities have far greater rights that they can raise in court. I think 2 points here. One is just, you know, these are, and some of the questions go to this as well, but these are draconian regimes, and, you know, when there has been a block and when there has been a block pending investigation or a designation, in some sense, the harm is done, right? And no one should underestimate, and I doubt, you know, people on this call would, the reputational damage that also occurs. That said, US entities and entities with substantial presence in the United States should be and can be asserting their Fourth, Fifth, and First Amendment rights. The more recent cases have been better on this, but unfortunately what we haven't seen is any public indication that the Treasury Department has revised its designation procedures to comport with the constitutional requirements of notice before search and seizure, due process, and protections against violations of the rights of free speech and association.
That's interesting because they haven't shut down a U.S. charity in so long. It looks like they don't want to use this process if they have to comply with the court orders and constitutional protections.
And I think in that way, just Kay, both Al Haramain and Kind Hearts, I think, sent a message, and previous administration wasn't willing to test that. What happens now with this administration is what I think gives rise to significant concern.
I'm going to move to questions from our participants, and one of them, are there any consequences for interacting with an entity before it's designated, and can you, interaction that may be legal at the time, but then that entity is designated at some later time? That sounds like an ex post facto constitutional violation to me, but I'll ask our legal experts to comment on that.
I think the answer is going to be that the U.S. entity, should have known that the foreign group was doing something wrong, even if OFAC did not. I mean, I haven't had to litigate that issue, but I don't think the government would accept that as an excuse. Maybe Hina had the better take than I do on that.
Yeah, so, you know, the criminal law, and the most relevant one is at 50 U.S.C. Chapter 35, it's Section 1705, and it imposes criminal penalties as well as civil penalties for people who violate or attempt to violate or conspire to violate the regimes. That said, so that would, you know, would be for criminal penalties, willful actions or conspiracies. That said, we have seen, and as Alan was pointing out in some of his slides, you know, people who are board members or officials of designated entities have separately faced investigation for things that happened before the designation and could themselves face consequences as a result. I think the key thing is, if there are, as Alan was saying, you know, to take internal procedures and audits and safeguards very seriously, to track sort of the internal processes for donations and so on and so forth, but also if there is any kind of concern to, and I'd say this for entities and people who are concerned about designation, to make sure that the materials that would be needed in order to defend itself, that they should be housed also, copies of those should be with lawyers, and there should be legal advice and counsel with respect to both compliance and safeguarding against the consequences of designation or block.
We have a question about the similarities and differences between the U.S. state and Treasury designations and the UN system of designations. Would either of you like to comment on that?
Alan, do you want to start? I only have a brief comment on that.
Go ahead.
Well, in terms of the United Nations process, it's done through the Security Council, and we've dealt with it for Al Haramain as well as one of the former officers, and we found the United Nations people be much more responsive to our request for information in terms of them providing us with information, and we were able to get one of our clients delisted by the United Nations as well as by the European Union. It's a much more open process to the UN. So that's why I recommend we have multiple designations. Start with the UN and the European Union, get delisted there, and then you can use that as the basis to convince OPEC to do the same.
I would just add there that, the UN regime has improved somewhat over time. I'm by no means much of an expert in that. And as a result, there have been some improvements with respect to the UN regime, but there's still significant concerns about, due process and protections within, what are essentially made up systems here, and ability to comply after the fact and see delisting after the fact.
I would also mention that the UN established a formal ombudsperson process, has an office where people who are listed under the UN regime can formally make a petition, a complaint to be delisted, and that is investigated. It is not a perfect process, but certainly much more robust than what the United States offers. We have the last question about intent and knowingly and unknowingly. How much does intent matter in determining guilt under material support, I guess the criminal provisions, or as a threshold for designation by Treasury? If an organization, even one with controls, could unintentionally provide some sort of material support as it engages in overseas assistance activities in very complex and dangerous environments, are they treated the same whether they knowingly or unknowingly provided support to an FTO or SDGT?
Well, the government has to prove that you knew you were working with or supporting FTO and that you were providing material support. There is an intent requirement. It's pretty low, but it's there. But that said, you don't want to take a hit in the sand approach and simply send money overseas, say, well, I don't know where it's going, so I'm not going to be responsible. I think you need to be, even though there's an intent requirement, I think you still need to have control over what you're doing overseas.
Can I comment on the knowing versus intent?
No, I think Alan covered it.
All right. We've got about 1 minute left. We have an additional interesting question, kind of more big picture, but it says some charities have been facing defamation attacks from media and social media, and then by politically motivated persons in certain countries, basically misinformation or disinformation, not based on evidence. They come up with accusations against charities that may be picked up, and in some cases has been picked up by members of Congress, could conceivably be picked up by Treasury or state. What can charities do in these situations? And this is bigger than a legal question, but let's go for it anyway.
Sure. I've done a fair amount of defamation work myself, and I have two observations. One, to the extent that people are simply repeating what the government has said in their designation, press releases or memos. That's, in a way, not defamation. It's protected because all the reporter is doing is simply repeating what appears to be a truthful statement by the U.S. government. So there's that defense to it. And the other sort of problem with defamation in this context is once someone is accused of terrorism, they become what's almost called the libel-proof plaintiff. In other words, nothing that's said about them would be defamatory because their name is already mud, their reputation is already trash. So they're saying anything more about them isn't going to make their reputation any worse. So it's unfortunate, but those are two key defenses in defamation cases. You're repeating something that the government said, and you're dealing with a plaintiff whose reputation is already tanked. So there's really not much you can do about defamation, unfortunately. I wish there were.
Can you give a comment on that one?
Yeah, just to emphasize, again, the very, the aspersions and the stigmatizing, deeply stigmatizing aspects of each one of these regimes, and that, there are when reporters report on it or members of Congress repeat allegations, you know, it's something that they have a right to do, especially when it's the government or government agencies that are charging these or blocking entities. That said, in very troubling ways, these are regimes that can be used politically and for political ends and purposes. And the redress, especially after the fact, is, you know, leaves a lot to be desired, to say the least. This is something that many organizations, including mine, have been looking to, you know, tighten the material support provisions and to get more rigor with respect to the Fourth Amendment and the Fifth Amendment with respect to designation here in the United States. And that is made harder right now, but it's still something that I think people should be considering and committed to trying to achieve.
Well, thank you, Alan and Hina, both for very in-depth and clear explanation of a very complex regime. We will be posting this webinar and the PowerPoints on our website. We will send you the links within the next few days. And also, any questions we didn't have time to answer, we will try to respond to those as well. So if you didn't have time to post them and you'd like to email me, please feel free to do that. The last thing I'll say is that the Charity and Security Network continues to work to change the legal rules that are so arbitrary, dangerous, and subject to political abuse. And one of the ways that we can do that is to all of us promote the good things we do. We don't often toot our own horn enough. To talk to decision makers, reporters, and others, give them examples of the kinds of robust due diligence and compliance procedures we use, and the importance of in the work that we do in assisting people in complex areas of being independent of government, of not taking sides in conflicts, of supporting human rights and humanitarian principles. And with that, we will close. Thank you, everyone.
Thank you all.
Thanks, everyone.